Good afternoon and welcome to the Appellate Division First Department. This is our oral argument virtually. People versus Jesus Acosta, 4-1 for appellant and 4 for respondent. MB Moda Bors versus Marks is 5-1 for appellant, 5 for respondent. Whoever has their mic on, please mute. People versus Darian Grant is submitted. Jackson versus Northern Manhattan wrongful death, versus Northern Manhattan is 5+1 for appellant, 5 for respondent. The case of Board of Managers, has the appellant appeared?
I am here for the respondent, Your Honor, Jerry Montag.
Thank you. Having indication that the appellant would not appear, the court has asked the respondent whether he wishes to submit and what say you, sir?
I would respectfully request to submit.
Thank you. You are free to leave the call. The case is submitted.
Thank you. Have a nice day.
You too. Goldman versus Nerds Broadway, appellant 6-1, respondent 6. State of New York, XREL Solomon versus Siemens Electrical. For both cases, we will argue them at the same time. 6-2 for appellant, 6 for respondent. People versus Christopher Erlanda. I believe that case is submitted. Ms. Rojas, did I get that right?
Yes, Your Honor, they did not show up, so we will mark it submitted.
Thank you. Austin versus 25 Grove Street, 5-1 for appellant, 5 for respondent. O'Neill versus NYPD, 4-1 for appellant, 4 for respondent. People versus Robert Thomas is submitted. Galino versus Everest Scaffolding et al. 5-2 for appellant, 4-1 for cross appellant respondent, and 2-2 for Galeno, Raymond Construction, and SSG Group. People versus Kevin Townsend is 5-1 for appellant, 5 for respondent. First case on the calendar, People versus Jesus Acosta, appellant, 4-1.
Yes, good afternoon. Emma Schriefter from the Office of the Appellate Defender on behalf of Mr. Jesus Acosta. During the plea proceedings and on the record, defense counsel gave blatantly incorrect advice concerning the mandatory immigration consequences of Mr. Acosta's conviction. There's no dispute here that his conviction would trigger mandatory deportation, and yet defense counsel said that this conviction may affect and probably will affect his immigration status. And we know from this court's clearly established case law that this was constitutionally deficient performance and mandates that this court hold the appeal in abeyance and remand for further proceedings. I would like to note that to the extent this court is concerned about the prejudice analysis.
Well, counsel, this is Justice Weber. Do we actually know exactly what information was given to the defendant based upon this record by his counsel? Because counsel did state that he stated to the defendant that the conviction would render him deportable, but we don't know. Do we know what else was stated to the defendant by counsel?
Your Honor, I don't know if I misheard you, but defense counsel never told Mr. Acosta that this conviction would make him deportable. He said on the record simply, this may affect and probably will affect his immigration status. And that's an equivocal statement. And we know from many cases in this department that equivocal statements about convictions that trigger mandatory deportation is not sufficient.
Well, on the record, the attorney stated that he had spoken to his client about the plea, that it would probably affect his immigration status, that he understood. Then the court says, asked the defendant, did you understand what he said? He said, yes. Then the court said, which means you could be deported, excluded, or denied citizenship. And he says, yes. So based upon the record, again, counsel said that he had spoken to him about how it might affect, how the plea might affect his standing. So again, my question is there really enough in the record to make a determination as to exactly what was stated to the defendant by counsel?
There is enough on the record. Yes, it's clear on the face of the record what defense counsel told Mr. Acosta. And we know from other cases, for example, People versus Picaro, that with the similar statement, which was in that case, there are potential immigration consequences. It's a very similar statement as to what was said here. The court continued to allocute Mr. Picaro in that case and similarly discussed the other immigration consequences, the deportability, excludability, and still this court found in his favor and remanded for prejudice hearing as we're asking here.
Okay, we'll hear you on rebuttal.
Great, thank you.
Great. Counsel.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. Defendant's claim cannot sufficiently be evaluated on the face of this record because defense counsel's explanation to the court that he and defendant had talked, quote, about how, end quote, his plea would, quote, affect his immigration status, end quote, was merely an answer to the court's inquiry and does not disclose or describe the advice that defendant actually received. Defendant's failure to file a 440...
Except that what's on the record is clearly wrong advice. So how do you get around that in light of Peguero?
Your Honor, again, I would go back to the use of the words about and how. This is not...
No, I go back to the word may. May is equivocal. It means maybe, not certain. And we know that the statute with regard to immigration consequences on this level crime is a mandatory deportation. So anything shy of that is wrong advice. How do you get past that?
Your Honor, again, I would dispute your characterization that this is in fact on the record advice. The court was inquiring whether there was an immigration issue in this case. A defense counsel explained that he and a client...
Counsel, if on the record at the time of sentencing, counsel makes a misstatement of the law, how is that not an automatic need to go back and make sure that the defendant understood what the true consequences were and that he would have entered this plea anyway if he did?
Your Honor, because, well, first of all, the vehicle of a 440 motion would allow the court to determine what that advice was. Again, the use of...
Except that again, you cannot get past what was stated on the record. You just can't. You cannot. The case law says you cannot get past that statement on the record.
Your Honor, I would also point to this court's decision in Gomez, which noted that unless it's irrefutably clear from the record what advice was actually disclosed, which I would dispute that in this case, I don't think we have that. I think we have an explanation of what a conversation that was had off the record. And Gomez, which cited McLean, the Court of Appeals case, which says unless it is irrefutably clear that the the statement on the record is in fact advice and that it is wrong, then the defendant is required to file a 440 motion in order to
But
determine.
counsel, this is Justice Weber. Obviously, it was wrong. I mean, he stated, I said to my client, we discussed how this may affect and probably will affect his immigration status. The bottom line is deportation would be mandatory. So he does not state that he told his, and so that is the misstatement of law. Deportation would be mandatory. It is not that it may affect and probably will affect his immigration status. It is that he will be deported because it would be mandatory based upon this plea.
Your Honor, again, I would distinguish this case from Gomez, or excuse me, I think this case is actually similar to Gomez. I would just distinguish it from the more recent cases that have discussed this issue, like Remigio. In that case, on the record, there actually is a statement. This is what I said to my client. I told him that I don't have the exact quote, but the distinction here is that counsel's statement is not advice. It is an answer to the court's inquiry about whether he had discussed the issue with his client off the record. And
well, counsel, since I believe I was a part of the panel on Gomez, if I'm not mistaken, thank you. I think I might be a little bit more familiar with the facts. And I think that in Gomez, what we stated was that there was an issue because counsel stated that we've looked into everything, we've considered everything, and we've discussed all the possible consequences of the possible plea. Here again, there is a distinction between this case and Gomez, because there you could not determine exactly what discussions were had. Here, counsel specifically stated, I told him he may be deported, and that is a misstatement of the law. Deportation would be mandatory. He didn't even say he may be deported. He said it may affect your immigration status.
I'm going to let you answer. You're out of time, but I'm going to let you answer Judge Weber's question.
Again, Your Honor, I mean, I think in this case, we don't have a statement of what the substance of counsel's advice. I think the use of the word, we talked about how it will affect his immigration status, is a vague statement that requires more clarification through a 440 motion, which was not filed in this case. I think if on the face of the record, there is some indication, this is literally what I told my client, then we would have a different story. But in this case, that statement is just far too vague to determine the actual substance of the off-the-record advice. And
I'm correct. I'm correct that the judge did not correct this misstatement of the law, correct?
Well, the judge did give a...
Did the judge correct this misstatement of the law and say, no, counsel, the defendant would be subject to mandatory deportation? Did the judge say that in clear, unadulterated truth?
No, Your Honor, but the court did give a proper PECE warning, which is all that it was required to do.
Thank you. All right, counsel, I'll hear you on rebuttal. And I took a minute off of your direct argument since you had made all your arguments, so you'll have an extra minute on rebuttal. You may proceed.
Thank you. And just to briefly address Your Honor's question about what the judge said, the judge also gave an equivocal statement about how this conviction would trigger mandatory deportation, and also said the word may rather than definitely will. If there's no further questions, I would like to rest on my briefing and my opening statements.
Thank you so much.
Thank you.
Moda Boris versus Lana Marks.
Yes. Good afternoon, Your Honors. May I proceed?
Yes, you may.
Thank you. Good afternoon, Your Honors, and may it please the court. I'm Jamie Mavora of Foxhorn and Camerini LLP for the appellant. The lower court dismissed this action as time barred. That was error. Under General Obligations Law, Section 17101, an acknowledgement of an existing debt revives the statute of limitations. An acknowledgement is a writing that recognizes an existing debt and contains nothing inconsistent with the intent to pay that debt. In March 2015, respondents acknowledge the October 2010 promissory note at issue in this action, reviving the
So this is Justice Webber. That's the email. Is that what you're referring to? The March 2015?
Yes, Your Honor. It's the March 2015 email exchange between the parties, the entirety of which is in the record at R55 through 58. On March 26, 2015, appellants sent respondents an email demanding payment. That email had the subject, "Payment Pending Invoices." It stated, "Since during phone conversation with Sandra, you informed us that you will pay us pending invoices as attached statement in 15 days, we ask you to confirm in writing what promised us, always keeping in mind that everything will be stopped until your answer." Appellant's email attached a document entitled Statement of Account, which is in the record at R57 to 58. That document was comprised of two components, one of which was a copy of the note at issue in this action, and the other was a statement of account that expressly identified the note at issue as an old debt from you agreed with private contract dated October 2010, not yet paid. On March 27, 2015, respondent Marks responded to appellant's payment demand. Her response is in the record at R55.
So, counsel, basically, you're stating that there is an issue of fact as to whether that email and the attachments constitute an acknowledgement of the debt and obligation to pay. Is that basically what you're saying?
At best, that's what it is. Respondent Marks stated, "You will get steady payments" in response to appellant's payment demand. And under this court's holdings, that alone is all that is required to acknowledge the debt under the note and revive the statute of limitations for appellant's claim. Respondent Marks's email recognized an existing debt to appellant, and it contained nothing inconsistent with the intention of respondents to pay that debt.
And so if in fact it acknowledged a debt, then therefore it would take it out of the statute of limitations, right, under the general obligations law. Is that correct?
Yes, Your Honor. And because that acknowledgement occurred in March of 2015, and this action was commenced in March of 2020, just 5 years later, this action was filed within the 6-year limitations period applicable to appellant's claim, and this action is timely. The lower court erred in dismissing this action as time barred. And for that reason, this court must reverse the lower court, reinstate this action, and remand for further proceedings.
This is Judge Owen. What's your response to the email that's dated January 12, 2017? Somewhat, it seemed that the Supreme Court relied on that email, saying that that was sort of like reviving the claim, but it was just way too long.
Yes, Your Honor, it was error for the lower court to focus on that January 2017 email chain. The respondents pointed to that email as evidence that respondents purportedly had already paid the debt. Otherwise, why would it not have been addressed in that email chain? But you're comparing apples and oranges here. An email in January 2017 about different transactions does not bear on the note that is at issue in this action, nor does it affect the plain text of the March 2015 email exchange, where in response to appellant's demand for payment of the outstanding debts, including the debts at issue in this action, respondent Marks responded, "You will get steady payments."
Well, that January 2017 email made reference to goods that had been supplied during 2013, 14, 15, and 16. But just because it didn't refer to the goods for 2007, 8, and 9, does that really mean that the motion court was in error in considering that email?
That 2017 email just doesn't bear on the issue that is on this appeal. It doesn't bear on whether in 2015 the statute of limitations for the claim on the note was revived. Appellants commenced this action because respondents did not pay their debt. Respondents are claiming in this appeal and in the lower court that they did pay their debt. Whether the respondents paid the debt at issue in this action is a sharply disputed issue of fact. We need discovery on that fact. That does not warrant dismissal of this action as time barred. And an issue of fact relating to the ultimate issue of liability in this action does not mean that earlier in 2015, Marks did not acknowledge the debt and revive the limitations period. Appellant should have an opportunity to probe this during discovery. I'm sorry, Your
Thank you.
Honor.
We'll have time on rebuttal.
Thank you very
Counsel?
much.
Thank you, Your Honors. Good afternoon. Jason Levine for the defendants' respondents. We submit that the motion court correctly dismissed this action as time barred by the 6-year statute, and that Ms. Marks's March 27, 2015 email did not constitute an acknowledgement under the general obligations law to
Why
revive
not?
this time barred claim.
Why not?
Because there's nothing in this email by Ms. Marks which recognizes Landmarks Limited's alleged debt under the October 19th, 2010 letter.
Except
and/or its intention to pay.
isn't her response, isn't her email in response to the statements of debt that were sent and invoices sent by plaintiffs, so that if once receiving those invoices, and there's no allegation that your client did not receive those invoices, am I correct?
The invoices for that are the subject of the October 19, 2010 letter. Yes, she acknowledges receipt of those invoices because those go back 3 years before that letter was entered into. That's not an issue.
It doesn't matter, but it talks about the debt. And so the point is, this email exchange she does not contest the debt that's being discussed in those statements.
I would dispute that, Your Honor, because as the motion court, I would submit pointed out.
How
what we have here-
tell me how the statement hold on, let me find the statement. You will get steady payments. Does that?
Right. I would submit under this court's case law, Your Honor, that statement in and of itself is insufficient to acknowledge this particular debt that's alleged under the October 19, 2010 letter.
Counsel, again,
Because
if the statement was, you will get steady payments, but we need to discuss what the accurate number is, then I'd agree with you. But there is no statement after you, let me finish. After you will get steady payments that contest the amount owed.
That's correct, Your Honor, but if we look at that statement, that's at page 57, almost every single one of those invoices are actually pending invoices from 2013 and 2014 for current business. I would point to this court's cases that we've cited in our brief, one in particular that's actually relied upon by the plaintiff, Banco Brazil, which sets forth what a writing needs to include in order to constitute an acknowledgement under the statute. In Banco Brazil, the defendant wrote the plaintiff a letter which specifically referred to this 1981 loan agreement, and then went on to specifically confirm 4 separate balances that were due and owing, such as the original loan amount, accrued interest, past due interest, and then adding up the 3 balances for the total due under this loan agreement. We don't have that here, Your Honor. And again, if the second case I would point to is cited at page 17 of our brief from this court, Atlantic National against Silver, same situation, where the letter from the defendant to the plaintiff explicitly referred to the particular loan at issue, its specific maturity date, and plaintiff's entitlement to immediate payment of the entire principal amount plus interest. Here, all we have is one blanket statement that you will get steady payments in reference to an email and an attachment, which there's no specific reference to the alleged debt under the particular October 19th, 2010 agreement.
So counsel, this is Justice Weber. In Banco Brazil, we said that so long as it was consistent with an intention to pay, that's all that needs to be shown. So why is that not what this email says with the attachment? Why is it not consistent with an intention to pay?
Again, Your Honor, because it has to be specifically referable to the particular debt under which this alleged debt was undertaken, and which in this case is the October 19, 2010 agreement. This email does not say that. It doesn't mention it, nor does the plaintiff's email mention that as well. I would point out the one that preceded.
So this is the 3211 motion, right? So therefore, why should we not it seems to me discovery would be necessary to flesh this out.
I would submit there is none, Your Honor. No discovery would be needed under these circumstances. I just think, the plaintiff moved by accelerated judgment. It's under 3213. And then we as the defendant cross-moved under various grounds. The one that the judge sought to dismiss the case on, which we submit was correct, was under the statute of limitations. Again, I point to this, and just picking up what Judge Oing had pointed out with respect to the January 12, 2017 email, the motion court we would submit aptly relied on that document to support its conclusion that the only document here which undertook an obligation to pay was the October 19, 2010 letter. Because this January 17 email never mentions either the October 19, 2010 letter, any of the defendant's obligation to pay the debt undertaken under that alleged agreement. It merely refers to 2013 and 2016 invoices for that period and makes no mention of the alleged debt that's owed for 2007, 8, and 9 for those invoices, which we would submit underscores the fact that they weren't asked for because they've already been paid, as we established in our cross-moving papers. So unless the court has any further questions.
Thank you
we'll
so
rest on
much.
the arguments in our
Counsel?
brief.
Thank you, Your Honor. I'd like to clarify and clear up some misstatements in my adversary's presentation. First, the statement of account that was attached to appellant's March 2015 demand for payment did include a reference to the promissory note at issue in this action. It expressly referred to an old debt from you agreed with private contract dated October 2010, not yet paid. I also want to address his claim that because Ms. Marks's email did not expressly refer to the debt, then that somehow meant that it was not an acknowledgement. GOL 17-101 does not contain any requirement that a writing expressly acknowledge a debt in order, or expressly refer to a debt in order to constitute an acknowledgement. In fact, last year, in the case of Hawk Mountain LLC versus Ram Capital Group LLC, this court found that a writing doesn't need to expressly refer to a debt or leave no room for doubt as to the nature and quantum of the debt in order to acknowledge the debt. The linchpin for whether a writing constitutes an acknowledgement is whether it imports an intention to pay. Respondent Marks's assertion, "you will get steady payments," could not be more clear of respondent's intention to pay the debt specified in appellant's statement of account.
Thank you so much, both counsel.
Thank you, Your Honors.
Thank you, Your Honor.
Jackson versus Northern Manhattan.
Good afternoon, Your Honors. May it please the court, Michael Cassell, Hogan and Cassell for the plaintiff's appellants, Patricia Jackson and the estate of Erwin Bird. As we set forth in our briefs, the lower court made two errors in granting complete summary judgment to the defendant, Northern Manhattan. First, the lower court erred by granting summary judgment as to the public health law. Second, the lower court erred as to granting summary judgment as to the wrongful death claim. With regard to the public health law, it's not disputed that at the summary judgment stage, the burden is on the moving party, which is the defendant, to rebut all allegations in the plaintiff's bill of particulars. Absent a showing and a situation where the defendant negates all allegations in the bill of particulars, the defendant is not entitled to summary judgment. In this situation, the plaintiffs clearly allege in the bill of particulars under the public health law violations of Regulation 10 NYCRR 415.11 and also 42 CFR 483.25. 415.11 requires that the nursing home facility put in place a proper care plan and also have a proper assessment done of the plaintiff. 483.25 requires proper protection from false. With regard to the submission by the defendant, they extensively relied upon their expert, a Nurse Kaufman. However, Nurse Kaufman does not ever specifically address in her affidavit these two regulations. She cites the public health law, that's true, but never sets forth any reference at all to 415.11 or 483.25.
Counsel, am I right? This is the appeal where the court credits the affidavit of one nurse expert, but not the other?
Correct, Your Honor. And in fact,
Wouldn't that disparity in and of itself be sufficient to defeat this motion?
Correct. And not only that, not only that, you have essentially two experts who are essentially identical. They're both nurses. They both have similar experience. They both discuss in extensive detail. Defendant's expert opines in extensive detail while defendant did nothing wrong, why they put in place proper assessments, protections, X, Y, and Z. And our expert set forth in specific detail, as the lower court even found, in great detail, every mistake that the nursing home did, while the nursing home did not do a proper assessment, specifically the August assessment put forth the wrong number as to Mr. Bird's fall risk, and therefore did not put in place a proper care plan. They removed the bed buddies. They didn't keep the bed at the lowest level. And our expert, Nurse Beavers, in explicit detail, explained why the proper protections weren't in place. So that is exactly correct. What we have here are two competing experts addressing essentially the same exact issues. So to the extent the court found that our expert, Nurse Beaver's affidavit was insufficient because she did never specifically use the term public health law, I submit that's a clear example of exalting form over substance. If you look at the essence of Nurse Beaver's affidavit, just like Nurse Kaufman, they address the same issues. Therefore, defendants didn't satisfy the burden of proof as to the issues, or even if they did, there were clear questions of fact as to the public health law.
Counsel, I'm sorry, this is Justice Weber. Did your expert address any of the specific rules or regulations that were violated?
Factually, she did unequivocally. Factually, she set forth in detail, 41511 requires proper assessment and care plan. Her affidavit went forth in tremendous detail. Lower court found as to why Nurse Beaver set forth that the nursing home did not do a proper assessment in August 2016, failed to put in place a proper care plan, and also did not put in place proper fall protection. So you are correct. The magic words are not in her affidavit, the 41511, nor 483.25, nor the public health law. But likewise, I submit Nurse Kaufman's affidavit never has a magic language to 41511 or 483.25.
Well, sir, I think at paragraph 21 of Nurse Kaufman's affidavit, she does make express reference to 10 NICRA sections 410 and 415 et sec. So Nurse Kaufman is, on my reading of her affidavit at paragraph 21, she at least does expressly acknowledge the regulations that served as the predicate for the public health law 2801-D cause of action. I didn't see any similar acknowledgement of those regulations in Nurse Beaver's affidavit.
Nurse Beaver's affidavit clearly does not use the magic words public health law nor the statutes. However, Nurse Kaufman's affidavit, you are correct, Your Honor. But in the vaguest of terms, she references sections 410 and 415 et sec. There's no specific reference of 41511, which is a key regulation, nor a specific regulation, a reference to specific regulation 483.25. The only reference is she says 42 CFR section 483 et sec. There's
right.
no.
Right.
Go ahead.
I'm sorry. You refer to magic words. I mean, it's a little bit more than magic words. Does not the affidavit have to specifically rebut the affidavit of the defendant's affidavit?
Well, if the court finds defendant's affidavit is sufficient as a matter of law, well, the starting point is defendant's affidavit must rebut every allegation in plaintiff's bill of particulars. If the court finds that that is the case, which I submit it's not the case, then Nurse Beaver's affidavit did rebut factually. Admittedly, she did not reference 41511 specifically or 43.25.
Well, that's my point. You keep saying admittedly she did not, but did she not have to? I mean, is that something that was not required?
It's not required because if you look at what she's saying factually, the exact factual requirements on the 41511, which is a proper assessment and care plan, are discussed in detail in her affidavit. On the 43.25, which is proper fall protection, is discussed in detail in the affidavit, and lower court found a question of fact as to these exact issues. It's a complete match. Sorry.
Counsel, this is Judge Owen. When you say that you didn't have to, you have a medical malpractice claim too, correct? Or am I missing something?
There was a
negligence. But you have negligence claim, right? So you have a negligence claim. So without specifically mentioning a specific regulation, I mean, everything that your expert talks about factually could flow into the negligence claim. It doesn't fall into the public health law claim. I mean, that's the problem. At least that's the problem I have. If your expert doesn't specify any sections of the health law, and factually she talks about all the problems, that goes towards the negligence claim.
I'm going to let you answer that, but you're over time, so this will be it.
Sure. It goes towards all the claims. The negligence and the malpractice claim, which the court found questions of fact on, those same exact questions of fact, the predicate to establish a violation of 415.11 and 483.25 are exactly the same factually, and that's why they all relate.
Thank you. Counsel, I'll hear you for Northern Manhattan.
Good afternoon, Your Honors. Mindy Batita with Caitlin Robin and Associates on behalf of the defendant respondent, Northern Manhattan. Just to briefly touch base with respect to the last point that counsel had made, with respect to making the same factual allegations for both public health law and for medical malpractice, he's essentially asking the court to make the legal arguments for him. He is not his expert has not explained or given reason as to why those facts apply to the public health law. She doesn't mention the public health law at all, so therefore she has not rebutted the defendant's expert.
Counsel makes the argument that that's form over substance. If we find that the affidavit mirrors factually the standard in the statute, why is that not sufficient?
Because they need to make an explanation as to why the appellant's expert controverts the respondent's expert. They
But
have
she
to address
does
specific
factually.
assertions.
There's no question about it that she does factually in great detail, as your adversary pointed out. Why isn't that enough?
Because the plaintiff's expert needs to address the public health law claim. The assertions in the Bill of Particulars state the allegations as to the public health law. The respondent's expert directly addresses the public health law. They are not directly controverting the public health law assertions, and therefore they're just making
Would you address Judge Oing's point that those allegations certainly support the negligence claims here?
They speak to negligence, but they don't specifically speak to the public health law. And what's at issue here is
but that's not the only action here, right? This is also a wrongful death cause of action.
Yes, it is also a wrongful death action. And yes, this is the case where they're dueling nurses as experts. But with respect to the accepting an affidavit of one nurse and not the other, it falls within the court's discretion to determine who is an appropriate
right. And but counsel, you understand that, of course, we are here to check that and make sure that what is good for the goose is good for the gander. And I don't know of any case where this court has allowed experts of same rank to accept one and not the other, because then the court is engaging, unless the court is talking about the substance, the court is then engaging in a credibility determination about the qualifications of these two experts, no?
Well, the qualifications of the appellant's expert was raised in the reply of the defendant. The expert of the appellant actually did not submit a certification pursuant to CPLR 2309 because she is an out-of-state expert, and she has not kept up with her expertise with respect to public health law and New York State. So they are not exactly equal experts, whereas the respondent's expert has. And so she has more of an expert opinion and experience, which has kept up with New York law.
Well, counsel,
Go ahead.
Following up on Judge Manzanet's point, her line of questioning here, there's a gatekeeping role that we play to make sure that experts are sufficiently qualified to offer an opinion, correct?
Correct.
Okay, and then once they meet that threshold, the degree and quality of their qualifications becomes a matter of weight and credibility for the jury, correct?
I would agree with that assertion, yes, Your Honors.
Okay, so in what manner or manners was plaintiff's expert nurse or purported expert nurse, if you will, was she unqualified to give opinion on matters relating to geriatrics and nursing home care?
With respect to just New York health law, she is not qualified in the New York State.
Okay, so how about, with putting aside public health law, what about the negligence component of the wrongful death claim? How was her opinion? How did she, in your opinion, how is she lacking the qualifications to give expert opinion in the fields of geriatrics and nursing care?
I would point to the fact that she is being used as a rebuttal witness versus being a witness that is establishing prima facie.
Okay. Anything else, counsel?
No, Your Honor, thank you.
Thank you so much. Counsel, you had 1 minute on rebuttal.
Sure, just 2 quick points. With regard to Nurse Bieber, the lower court clearly found that her opinion was more than sufficient as to the negligence and malpractice claims. There was no cross appeal, no argument that our expert was insufficient or not medically qualified to render an opinion. Secondly, I submit that the key flaw of the lower court's reasoning and the defendant's position that somehow as to the public health law, Nurse Bieber's failure to cite the specific regulations, the problem with that, and I know Judge Higgett pointed to paragraph 21 of Nurse Kaufman's affidavit, it's A35. I asked the court to look at that paragraph. Nowhere in that affidavit, that paragraph, does Nurse Kaufman specifically reference 41511 or 83.25, and it's clearly defendant's burden at the summary judgment stage to establish as a matter of law that there's no violations of those regulations or in the bill of particulars. Defendant did not satisfy its burden as a matter of law. Thank you.
Thank you. Goldman versus Nerds Broadway.
Good afternoon, Your Honors. May it please the court. Nerds was canceled on March 8th, 2016, resulting in the total loss of plaintiff's investment. Plaintiffs were not early investors. Some of them had invested just days before without any warning that that the play and that the venture was on the verge of collapse. According to the defendants, the cancellation was due to 2 things: a large advance to the Schubert organization and the loss of a major investor. But as defendants' own emails, which I have on pages 351 to 360.
Counsel, Judge Owing is trying to ask you a question.
So let me ask you a question. When the plaintiff investors put in their money, invested in this production, the Schubert lease had already been entered into, correct?
Some of them, yes. Some of them.
Did they all? When did? I'm not looking for some. I'm looking for all the plaintiffs. When they put in the money for this production, it was after the Schubert lease had been entered into, which was entered into, I think, several weeks earlier.
I believe that the earliest investor was back in, I believe, in February, and I believe you're correct. I think the Schubert organization lease was entered into in January, but the payments had not been made yet.
It doesn't. but the Schubert lease had already been entered into because the basis of this complaint, and I understand the thrust of this complaint is the Schubert lease, because in a footnote in your complaint, you complain there's some other activities you're complaining about post-investment, but you never went into detail what the post-investment activities were. So I'm only left with the Schubert organization. So that how do you get around all the disclaimers that the investors signed on to that are included in the investment package?
So there's two. I'm not sure. There are two claims that we make. One are the fraud claims, and one is the gross negligence claim.
Right.
The gross negligence claim.
But that all flowed from the Schubert lease, correct?
No, the fraud claim flows from the fact that they were advised that the subscription, that all the money was in place, and that they specifically had investors such as Zuckerberg.
Counsel, all of the statements that you are referring to in your complaint are just that, statements. They are not a part of the writing. They are not a part of the written agreement. And the written agreement clearly says, has a merger clause that prohibits consideration of any statements made outside of the confines of the four corners of the agreement. Am I correct?
Yes, we're relying on the fact that the merger clause was a general merger clause, and we're relying on the law that says in order for a general merger clause to bar parole evidence of oral representations outside of the contract, it has to specifically disclaim.
This contract language was as tight as I've seen it. They made it very clear that you are not relying on any statements made outside of the agreement, period, full stop.
Well, except for the fact that under section 11.1.3, they specifically say that the plaintiffs had had an opportunity to ask questions and had received oral responses.
It also said that the plaintiffs assert that they had full opportunity to inspect the records, to inspect the books, to have an independent accountant, attorney, whoever they wanted, to look and do due diligence.
And
Your
yes.
people obviously didn't do that, because if they had, they would have certainly known about the balance sheet, and that this Schubert Theater lease, once that payment was made, would wipe out the account basically.
Well, but they wouldn't have known that that there were claims made that the venture was completely subscribed, that all the money was in place, that there were investors that were in the wings, such as Microsoft and Zuckerberg, and that those people would not be reflected in the books and records of the company. And significantly,
why not?
Because those are things that would only have been in the knowledge of the plaintiffs. It would not have been reflected in the books.
So that Microsoft would and Facebook would invest millions of dollars in this production and not have a writing?
These were commitments that were allegedly made.
These are businesses that do things on paper. Come on.
But
you don't commit $1 million to a Broadway show and not get that in writing and believe that it's real until it's in writing, or you have the check in the bank.
They said that the matter was fully subscribed and they had the money lined up, and that would not have been reflected. And that is the representations that my clients relied upon. And those would not have been reflected in the books and records of the company. Those kind of representations were made outside the contract. And in fact, as I say, and the court below did not find that the plaintiffs did not sufficiently investigate. They didn't find that for some reason that there were red flags that they missed.
Well, what did you do to find out what money was in the bank? What did you do to find out what firm commitments there are other than their say-so? Because it wasn't in the contract.
Yeah, but those firm commitments were those were the oral representations that led us
in the contract. So what due diligence did your clients perform to try to confirm these quote unquote representations that the contract said you could not rely on?
Well, remember that this is at the motion to dismiss stage, and whether or not the plaintiffs reasonably relied upon those representations is a matter of fact and not a matter of law for the court on a motion to dismiss. We'll get into all of that.
Justice Weber, why is it even an issue when the contract specifically says that they're not bound by any promises, statements, or representations other than what are expressly specifically set forth herein.
Because as I understand the law, and we cite basis yield and Lorelei and other cases in our brief, the law, it seems very clear that a general merger clause or even a general disclaimer of reliance clause is not sufficient unless it specifically disclaims the representations that are alleged by the plaintiffs to have been made. And in this case, not only do we allege that these representations were made to us outside the contract itself, which was drafted by the defendants, not us, says that we had an opportunity to ask questions and receive answers, so that it itself recognizes that there were representations made outside of the contract. It's those representations that we
You'll have time on rebuttal.
Thank you, Your Honor.
Mr. Kupperman?
Good afternoon, Your Honor. Zachary Cooperman for defendants' respondents. There is much more than just a general merger clause. Of course, these contracts did have general merger clauses, operating agreement section 12.3 and subscription agreement 5C. But of course, as Your Honors noted, there are several no outside representation clauses, and these no extrinsic representation clauses, this court has repeatedly upheld as being sufficient. Most recently in Kim versus XP Securities, D'Artagnan versus Sprinkler, Avnet versus Deloitte Consulting. So it's much more than just a general merger clause.
Sir, what is in your view, the strongest, most specific disclaimer clause?
They're all together. It's both the general merger clause, which says this is the complete agreement, no outside representations. It's operating agreement sections 11.1.1 and 11.1.3. And again, in subscription agreement 2A, it's as clear as day. No outside representations, no oral representations. You're not relying on anything outside the contract. And these are specific enough. It couldn't get any more specific. If the fraud is alleged to be something like the money is all in place, the contract specifically, additionally, in addition to these no oral representation clauses, also said, no, the venture is not fully capitalized. It might never be fully capitalized, and the finances might be insufficient to pay its debts. So altogether, this contract's are ironclad.
Join. I have a question. So that I want to peel it back even a little bit more. Go back to the very beginning. A standing issue that was argued by you folks. I mean, this is a derivative. These are derivative claims, right? I mean, the plaintiffs here didn't suffer any different harm than any other investor, correct? So it's a derivative claim, and it goes to the company, correct?
It does, and they didn't plead a pre-action demand.
Holding that thought about it being a derivative claim, it goes back to my point earlier that they were not shareholders. They were shareholders after the fact. I mean, their claim is that the Schubert leases, the whole thing that sort of undermined everything, putting aside not getting a fully subscribed investment, but the Schubert lease is the one that really tanked the whole deal. At least that's their allegation, right? So, but their investments came in after the fact.
That's exactly right. The earliest investment was in January 22nd, 2016, according to the complaint. You could see based on the documentary evidence of the date that the subscription agreements were signed, that as well for the earliest date of the earliest investments, and the Schubert lease is alleged to have occurred in early January, and the first deposit on the Schubert lease is January 11th. So yes, under the contemporaneous ownership.
Right, and I didn't see anything in the complaint that alleged any other acts or conduct on behalf of the defendants that would support any derivative claim. I mean, it just seemed to all circulate around the Schubert lease.
That's exactly right. That is the absolute look. The complaint and the plaintiff's attorney uses buzzwords like bad faith and willful misconduct, but there's absolutely no allegation of any kind of willful anything. In the plaintiff's reply, he also mentions that the managers were also investors. Even if this is true, there's no way that this is any kind of conflict or any kind of bad faith. Yes, and under the contemporaneous ownership rule, the plaintiffs wouldn't have standing ab initio. And to plaintiff's point that the plaintiffs themselves warranted that they had an opportunity to ask questions. Well, it's exactly that. It's plaintiff's promise that they had this opportunity. The defendants are not warranting that there was outside representation. So there's no logic or law that says that you can't buy a plaintiff's promise that they've had the opportunity to ask questions, and somehow this vitiates no oral representations clause. And to plaintiff's point that none of this was reflected in the books and records of the company, well, of course, that's the point. If you looked at the books and records of the company, you would have seen that there was no such investor.
Did any defendant look at the books perform any due diligence of that sort?
The plaintiffs warranted in the contract that they did all their due diligence, that they completely inspected, that they and their financial advisors had the opportunity.
Okay, let me ask the question another way. Did the defendants here prohibit the plaintiffs from looking at the books?
Absolutely not. In fact, before filing this complaint, the plaintiff's attorney and the plaintiff's accountant in this very room that I'm sitting inspected the full books and records for 3 days. This was attested to by plaintiff's counsel with actual knowledge of the fact in the court below. Unfortunately, it's not in the record because we couldn't add this to the record on a motion to supplement the record. But I think this goes to whether or not plaintiffs should be able to replead. They've had a full and fair opportunity to inspect all the books and records. The only thing that they can come up with is the Schubert contract, which besides being simply an alleged imprudent business decision, occurred before any of these plaintiffs had even invested.
Thank you. Counsel, you have 1 minute on rebuttal.
Thank you, Your Honor. Justice Owen's point, the fraud claim is not a derivative claim. I'll just, as Your Honor knows. And as far as whether or not plaintiffs did due diligence, that's the kind of factual determination that is not to be decided as a matter of law. And if you're, and the court below didn't rely upon that, I would suggest that since you're a reviewing court, if you have any problems with that, on that score, you should remand it back to the judge for a full determination on whether or not the reliance was reasonable or not reasonable, because this was dismissed at a motion to dismiss stage, and that issue
wouldn't
not.
Counsel, why would we remand if you have not asserted in your own papers that there was an attempt at due diligence and that something improper happened?
Yeah, the complaint.
You don't even assert that.
Yeah, the complaint says that we reasonably relied on those, and there's no reason that we shouldn't have relied on those. And as far as what the due diligence is, that is a matter of fact, which either we get a chance to replead or you remand to the court for a full determination on whether or not the plaintiffs were reasonable in their reliance or not reasonable. But that kind of issue should not have been determined on a motion to dismiss. If anything, send it back down. And okay, thank you, Your Honor.
Thank you.
Thank you.
Have a good day. State of New York and City of New York, ex-rel Robert Solomon versus Siemens Electrical LLC.
Good afternoon, Your Honors. My name is Robert Sadowski. I represent the plaintiff, appellant, and relator in these False Claims Act cases. My name is Robert Sadowski. There are two cases that we're set for oral argument to hear. One involving dangerous code violations at the Croton Filtration Water Plant.
Counsel, I just want to reiterate, these cases are being argued together. You have 6 and 2 to argue both issues, okay?
Yes, Your Honor.
Proceed.
Okay. There are two decisions in this case, and the lower court got it wrong in several instances. One, the court looked at what it considered documentary evidence of meeting minutes of New York City committees. Those are not documentary evidence. They are not items that effectively refute the plaintiff's allegations in this case. There were summaries. They're not source documents. They're not electrical documents. They cannot be considered as documentary evidence. The lower court did, and for that reason alone, the case should be vacated. I want to go back and talk a little bit about the contract between the DEP and Siemens, because it's unusual in some respects. The DEP contract, which is unique to the Department of Environmental Protection specifically states that finished or unfinished work not found to be in strict accordance with the contract shall be replaced as directed by the engineer, even though such work may have been previously approved and paid for. Such corrective work is contract work and shall not be deemed extra work. That is within the contract. So what we have here is there were no approvals. While there were payments, there were no approvals. And on the argument in the lower case, the city disagreed that the allegations did not put the city on notice, not until someone can independently inspect the facility. The other requirement here in the contract, which may be unusual, is that it put the onus on Siemens to review the specifications and plans submitted by DEP, correct electrical code violations on the plans, report those violations to the DEP, institute and install corrected specifications for electrical installations, and keep the corrected plans for future repairs. The city paid for this engineering work, and it was not done. The thing that was done is Mr. Solomon, by himself, took the 1,400-page specification and code book, went to the plans, went to the facility, and found, after a short review of those specifications, that there were 178 critical violations of the electrical code. Let me give you an example of one. If there's a circuit breaker that's set at 60 volts, but the conduit and the current that's running through it is 80 volts, that circuit is going to break over and over again, shutting down operations of the plant. Now, if the circuit breaker is set at 100 and there is more voltage flowing through, that circuit maker may not break, and it may cause the circuits to heat up, cause fire, and catastrophic explosions within an area that's densely populated.
Excuse me, sir, was the city made aware of these alleged violations?
Mr. Solomon pleaded vociferously on these allegations, but that's what they were, allegations. The city did not have the facts. And why didn't they have the facts? Because Siemens concealed the installation of code violations. They were poured in the slab. They're not there for the
Counsel,
naked
you're running out of
eye.
time, and I strongly suggest that you try to be succinct in answering questions of the court, because you're giving more detail that we have read through. You really need to get to your argument. Why is the city's decision to pay, why doesn't that not end the question here?
Because
they heard about the allegations, whatever investigation, whether your client thinks it was sufficient or not, they conducted and they paid. Why is that not the end of the story?
Because of the contract, which provides that payment is not approval. And secondly, because the violations were concealed, and allegations are just that, allegations. Case law is clear. They have to know facts. What they know are allegations. That's the difference in this case.
So are you saying that there was no independent investigation by the city?
Absolutely correct. That's absolutely correct. The city couldn't. And when the city did do investigations, they put Siemens on notice. And pages 629 through 637 of the record shows findings that the inspection for the city made which dovetail with many of Mr. Solomon's allegations. And the city reports to Siemens, quote, SSE Siemens is proceeding with the work in this area at their own risk without an approved drawing. There were no approved drawings because Siemens never took the required move of correcting those drawings to reflect what is actually should be installed as code compliant electrical installations.
Okay, you'll have time on rebuttal. We're out of time.
Thank you, Your Honor.
Ms. Schwartz?
Good afternoon, Your Honors. May it please the court, my name is Wendy Schwartz from Binder and Schwartz, representing the defendants' respondents. This case is one of a lengthy series of cases brought by Mr. Solomon, aggrieved by the fact that very early on in his relationship with the Siemens defendants, they determined that he and his cohorts were not providing the services they were supposed to provide, and effectively removed Solomon and his company from participating any further in the contracts. Since that time, there have been many investigations by the city, by the Department of Investigation, by the district attorney's office, in other lawsuits. There is no way that anyone could claim that the DEP did not have the information it needed and a full and fair opportunity to investigate, make its own decisions, and determine whether or not it was going to continue to pay Siemens for the work that was being provided at the Croton site. Specifically with respect to the allegations in Mr. Solomon's complaint, Mr. Solomon had complained in detail to the Department of Investigation in 2011 and to the Department of Environmental Protection in 2013. And at page 12 to 14 of our brief, we show a comparison of the complaints that he made at that time and the complaints that he makes now, and they are virtually identical. It is not correct to say that the city needed to know specific facts in order for their payment to be made, and for the fact that those allegations were not material to allow them to pay and continue on. The only thing that the city needed to know was that the allegations had been made and that they were able to investigate them. And once that happened, regardless of the results of the city's investigation, if they continued to pay, and here they did investigate, then we can make the reasonable assumption under the case law that whatever those allegations were and whatever the underlying facts might be, they are not material to the city's payment under the False Claims Act. One very important concept underlying this entire case: this is not a contract case. This is a fraud case. If Siemens violated the contract, which seems to be what Mr. Solomon at bottom is alleging, then the city can address that in a contract case. The city can also address that violation of contract, by the way, by not paying, which they did not do. Here, Mr. Solomon is alleging a fraud case. And for a fraud case to stand, there has to be evidence that the Siemens defendants knowingly withheld information from the city or misled the city, and that was material to the city's payment. Here, the information was in front of the city in numerous ways. And so when the city paid, we can make, again, the assumption, a reasonable assumption, that whatever they were hearing was not material. I want to respond to the documentary evidence point that Mr. Sadowski raises, because his argument is ignoring the long line.
Let me just stop you for a moment. Some of these allegations certainly speak to the safety of this future filtration plant. So to the extent that there is any truth to some of these technical allegations about, systems that could explode, for instance, if what he described sounded like a mega power surge that could happen and blow things up, right? So either it was investigated and not found to be accurate, in which case not material, or because to me that would be the only proper finding, that it's not material, that the allegation was not true.
Your Honor, there is,
understand these cases, especially now, are being heard by the public, and anyone who is within the map of this Croton facility is not going to agree with you that those allegations are not material. So when you say the city, obviously by choosing to continuing to pay, found that those allegations were not material, are you saying that they found them not to be truthful?
I am, yes, Your Honor. In fact, in the record at 206, we have an express statement by the DEP made in 2014 that says all of Mr. Solomon's correspondence that alleges problems with safety and or improper work have been reviewed and evaluated by the DEP. Where any items are legitimate, they are immediately addressed. Other concerns have not proven accurate. An independent monitor has been employed on the project since 2007. DEP will continue to review any issue raised by Mr. Solomon. Now, I will note that that statement was made based on prior correspondence from Mr. Solomon that tracked exactly what is in his current complaint. And that's why I referenced page 12 to 14 of our brief, because you can see the chart in there that demonstrates the allegations. I see that I'm out of time. I would just like to say—
I interrupted you, so I will give you another minute if there's another point you need to cover. And I will do the same for the other side. Go ahead.
Thank you, Your Honor. I have two very quick points. My first point is with respect to the documentary evidence argument, Mr. Solomon's counsel ignores the long line of First Department cases that make very clear that emails and written agreements and meeting minutes and letters that are essentially undeniable are appropriately considered as documentary evidence. The Second Department cases cited by Mr. Solomon's counsel are not to the contrary of those. They're more off topic. My second point simply is we haven't discussed the gratis pay case, and that's the second appeal. And on that appeal, I will just say we have in our papers shown the extensive amount of public disclosures that were made prior to Mr. Solomon filing his action, and that is dispositive under the case law that we cite. Thank you, Your Honors.
Okay. Counsel, I will give you an additional minute. Unmute so we can hear you, though.
Thank you, Your Honor. I'd like to address the gratis pay case first. It's undeniable that Mr. Solomon was one of the 5 members of the board. He works on the team estimating. He was the day-to-day manager. He's worked in this industry for more than 50 years, and he knew personally the foremen and the men working on the project, knew their schedules, knew their comings and goings. He has the certified payroll records. No one else does. Until his complaint was unsealed, no one knew the name Siemens in any connection whatsoever with the gratis pay scheme. He provides a wealth of information. He's a high-level insider. He's precisely the type of individual the government looks to end fraud and bring it to the government's attention. Now, going back to the electrical case for a minute, counsel raises 2 items that they consider documentary evidence, meeting minutes from 2013, 2014. Those meeting minutes addressed 2007 and 2008 temporary installation. Mr. Solomon does not have allegations relating to the temporary electrical installations. Last point I'd like to make is all the recriminations
You have
that
30 seconds, please.
all the recriminations that have been raised against Mr. Solomon are unfounded. He works in the construction industry. Being a litigant in a construction industry is not a detriment to someone who's become a hero in blowing his whistle. He was removed because he blew the whistle, because he told the CEO that 178 code violations exist, and I've only touched the surface of this. You have to report this. Mr. Dung refused.
Okay.
On that, Your Honor,
Thank
we'll rest
you.
the nerve. Thank you, Your Honor.
Have a good day.
Thank you.
Austin
Thank you.
versus 25 Grove Street.
Good afternoon, Your Honors. If it pleases the court, my name is Joshua Price. I'm the attorney for the appellant. May I be heard?
Yes, you may. You have 5 minutes.
Thank you, Your Honors, and good afternoon again. This appeal presents 3 issues to the court. The first issue is, and I think this is the most important one, is that it is the appellant's contention that the court below committed reversible error in finding that there was an overcharge and determining that there should be a monetary award to the plaintiff tenant, who's the respondent in this appeal, because the statute of limitations bars such a recovery. Over the years, the statute of limitations is something that has been bandied about as it's gone from trial courts up to the Court of Appeals and back. The Court of Appeals in the Regina case seemed to really put its foot down and place its firm imprimatur on the idea that the 4-year statute of limitations, they really mean it this time. And in that decision, they went so far as to criticize holdings in decisions that were not actually before them to make the point that the 4-year statute of limitations is really a 4-year statute of limitations. In this case, the plaintiff tenant paid precisely the same rent for more than 48 months immediately prior to starting the overcharge case.
Counsel,
Given that they paid exactly the same amount of money for more than...
Counsel,
Yes,
Judge Oing has a question.
Judge Oing.
I'm sorry, I didn't hear you, Your Honor.
Yeah, I'm sorry. Yeah, it's this video stuff, this virtual stuff is really difficult, but I have a question. The overcharge claims in this case, the plaintiffs, they make allegations of overcharge post 2019 of the HSTPA enactment? Yes or no?
Yes. It's
Okay.
both. It's before and after.
I think we can agree that.
But it's an easy question. It's before and after. Yes, it's both.
It's before. We have overcharge claims that are before and after. So that when you say Regina applies to this case, Regina was talking about before. I mean, it did a tremendous amount of discussion about the type of claims or overcharge claims before the enactment because it had to. But these claims in this case here, they cross over the threshold. They're after the enactment. So when you talk about the 4-year statute of limitations, I'm not so sure that that really swings to the claims that fall out after the enactment of the HSTPA.
Well, Justice Owen, you ask a very particularized question that really sort of gets to the heart of certain things, except for the problem that in this case, it wasn't an argument that was advanced by either side. That's not really what was going on here.
Mr. Price, I'm going to stop you for 1 second. I don't know what happened, but we are now getting feedback. So I'm going to need you to speak a little slower so that we can actually understand you. Okay?
Yeah.
Let's try. Go ahead.
As Justice Owing said, this video stuff can be very difficult. And so the point I was trying to make was that the issue that Justice Owing presents, the issue that he presents in his question, what really before the court below. The defendant moved for summary judgment, basically saying there was a statute of limitations issue, that there was no dispute as to the regulatory status. It was something that the landlord had conceded. And we contended that the only reason that the tenant was pushing the regulatory status issue was so that it could be awarded legal fees at the end. The plaintiff tenant cross-moved for summary judgment, but only cross-moved for partial summary judgment, and simply made the argument that please determine that we're rent stabilized because we are, and determine that there's an overcharge and we'll figure everything else out later. The court below went far beyond what either party was really advocating and didn't give either party an opportunity to really be heard on the issues here. And just as a for instance, it's not part of this record, but the court can certainly take judicial notice of anything that would happen within the context of this case.
Oh, let's not
After
do that. Let's not do that.
Okay.
We certainly have enough on these facts to be able to move forward. You have time on rebuttal. Counsel, I'll hear you on your response.
Thank you very much. May it please the court. My name is Ellery Ireland. I'm an associate David Rosenholk and Associates, and we represent the tenants in this matter, Francis Austin and Francis Austin and Marie Austin. I'll try and speak slowly. I'm going to adhere to my colleague Mr. Price's three issues. The way he framed it, there are three issues. The issue that he seemed to be addressing at the end is something that both parties are in agreement on. The tenants here did not move for the court to reset the rent, and they did not move the court to assess overcharge. These are things that were not noticed. They were not briefed. The evidence wasn't before the court, and the court's analysis is completely inconsistent with the law. As a little update, I even moved to re-argue that issue, and the court boldly adhered to its original determination, which is just wrong. So that second issue, there's no disagreement. It should be remanded. As I will explain, it should be remanded for further proceedings consistent with this court's adjudication. The default formula should be applied pursuant to the Rent Stabilization Code. But what I want to spend most of my time addressing is my colleague's first argument, that even on the issue of liability, the lower court was wrong. The landlord's position here that Regina cabins the analysis to the 4 years prior is, as Justice Oing pointed out, problematic because this is a post-HSTPA case, and all of the cases in this department analyzing Regina have been cases that were filed in Supreme Court prior to the HSTPA. I'm talking here about Montera, the Montera decision, 435 Cent Park, Casey v. White House, matter of AEJ 534. These are all favorable cases for the tenant's position. Notwithstanding that, they are all pre-HSTPA litigation. This is a post-HSTPA case. The notion that the tenant didn't bring this up is false. It's on page 127 of the record.
I thought I read it somewhere. Okay.
It wasn't a point that was belabored because there's not a lot of litigation. I can't cite to an appellate division case that says the HSTPA should now be applied. But also, even using the old standard with the fraud exception to the 4-year, the case was clear. There was abundant evidence that the fraud exception should be invoked, even if we applied the old laws. And the landlord's argument that Regina limits all analysis, no matter what, to 4 years has already been rejected by this court in the 4 cases that I've said. And I'll quote this court in its decision from Montera, which says,
Counsel, I got to ask you a question. We don't need you to quote anything. Let me ask you this question. In terms of the fraud analysis here, I'm starting to think, I didn't understand why the landlord was so much against a declaration that your clients were entitled to a rent stabilization lease. Because I hear the arguments that he says, look, we concede or we admit that there was always a rent stable, this apartment was always subject to rent stabilization. So there should have been a declaration of that in your favor of that point. What's really behind that sort of opposition? Can you explain why he's so opposed to that?
So I don't know what my colleague Mr. Price is thinking, but I can just correct a misstatement that he made. which is that it's motivated by a desire for attorney's fees, because statutory attorney's fees are available on a rent overcharge claim under both the rent stabilization law and a rent stabilization code. There's no statutory attorney's fees for a status declaration. In fact, my understanding of the case on this subject is that even lease-based attorney's fees claims are looked upon disfavorably in declaratory judgment actions because they don't arise out of the lease. So Mr. Price's representation that it had to do with a desire for attorney's fees is wrong. Our attorney's fees are based upon the RSC and the RSL because of overcharge.
Thank you so much. We're out of time.
Thank you very much.
Mr. Price, you have a minute.
Okay, Judge, statute of limitations. So let's say that this is a post-HSTPA case. So the HSTPA said that there's a 6-year statute of limitations instead of a 4-year statute of limitations. The tenants moved in and began paying the rent in 2013 and brought this case in 2020. So they would be beyond the statute of limitations anyway. It's 7+ years.
No statute of limitations, a 6-year look back period. I don't think there's a 6-year statute of limitations.
Right.
It's a 6-year records retention look back. Because now the statute says you can bring the overcharge claim at any time, which indicates to me that there is no statute of limitations. I mean, it's just the 6 years is the look back.
Well,
Did I read
as
that
my
wrong?
colleague pointed out, there isn't a lot of case law fleshing this all out yet, but it would seem to me that the 6 years that are described in the HTSPA would prevent a claim here because the overcharge is more than 6 years in the past if there is an overcharge.
Thank you.
Because I know I have very little time on the
You have
legal
no time left. We're done. Thank
And I
you
have
so
no time
much.
left.
We have your papers. O'Neill versus New York City Police Department.
Hello, I'm Maura O'Neill.
You may proceed, ma'am.
So there are 3 material issues that are the subject of this appeal. The first is that the NYPD sent me materially redacted police reports. Yet in the respondent's brief, Corporation Counsel claimed the NYPD provided records that contained only minimal redactions, although this is clearly not the case. Instead, the NYPD has used a FOIL exemption for non-routine techniques and procedures to withhold portions of my police reports, claiming that it's moot. However, it's very obvious at this point that there's material portions of the police reports that I do not have, that I've never been given, and that I should have been, under the FOIL laws, I should have been given access to these very material parts of my own police reports. So for example, the NYPD materially redacted a police report regarding a sexual assault at the Shelbourne Hotel in 2018. The report from the OCME showed that there was male DNA and sperm on my genitalia, yet the NYPD closed the case at the Shelbourne by using a video of me that showed that I had significant language deficits and appeared confused because I had been drugged. Yet none of this, by the way, is actually in the police report. I found this out from other people. And then to cover up for the language deficits and my confusion, as a result of the fact that I've been illegally drugged, a fake stroke story was generated to cover for the NYPD's use of video to close the case at the Shelbourne. Yet all these facts in the police reports have been redacted, and then over time, the NYPD keeps changing a story as I keep proving that stories are false. In the respondent's brief, Corporation Counsel claimed that these fake stories about me about having a stroke that I don't have, having neurological problems that I don't have, is somehow just a mere digression. But obviously, falsely claiming someone had a stroke and has neurological problems isn't a digression. It's pretty disgusting to do to someone. Making up fake medical diagnoses is ridiculous. I'm sorry, is there someone say something?
No, continue. You'll hear us if we want to ask a question.
So not only did the NYPD close the criminal case of the show.
So I'm sorry, ma'am. I think someone else on this call has their microphone on. Please turn it off. We're
Okay,
getting
that's what it is.
feedback. Everyone on the call,
So
other
not
than
only-
justices. Go ahead, Miss O'Neill. I'm so sorry.
That's okay. So not only did the NYPD close the criminal case at the Shelbourne by falsely claiming I had a stroke I never had, but the NYPD went further in its filings in the Article 78 petition by claiming I spun a tale, even though that too is completely false. In addition, the NYPD also made phone calls to attorneys from my former employers after I filed the petition in 2019 and told lawyers from my former employers I was crazy and a liar, which is ridiculous because there's nothing in the police reports proving that I lied about anything. So basically, the NYPD basically makes up a bunch of these stories, makes a bunch of phone calls about me behind my back, and yet none of the information that they're basing this on is actually in the police reports that I have access to. And so it's pretty ridiculous. So the material issues of why they closed cases and why they did what they did is information I don't have access to. And so I'm not able to properly defend myself because I don't even know what I'm being accused of. And then as I basically hear things from other people, I'm basically being forced to basically, you know, file new motions, and basically after I file a motion explaining why they're wrong, then they just come up with a new crazy story, which is exactly what happened in the respondent's brief. So the Article 78 petition was filed in June of 2019, and yet in the respondent's brief, which was filed on December 8th of 2021, for the first time, Corporation Counsel decided to claim that it was my fault for not telling the police that it was Wilder who drugged and sexually assaulted me, even though I told the police, had been telling the police about Wilder since 2017, which is not debatable, since as shown in Exhibit 2 to the petition, there was a CCRB complaint, which is shown on page A45 of the appendix for the appeal, which basically shows that in 2017, the NYPD was on written notice about my complaints about Wilder and about the fact that he had threatened to drug and sexually assault me. So the fact that this story that they spun out in December of 2021, claiming I'd never told them about Wilder's, quite honestly, it's ridiculous. And the problem that I have is that the reason that they're able to keep changing their stories and lying is because the material sections of the police reports have all been redacted.
Thank you. Let's hear from the other side and you'll have time for rebuttal, okay? Counsel.
Good afternoon, Your Honors. This is Ellen Ravitch, and I'm here for Respondent Police Department. This appeal brings up only issues related to Ms. O'Neill's FOIL request and her sanctions motions. And I mention this because a review of her briefs reveals that she discusses many issues not on point here, such as hospitals' obligations regarding medical records, Medicare and Medicaid issues, and the False Claims Act. As I have only 4 minutes, I will limit my argument to a few key points, though, related to the issues that are actually on appeal. So first of all, the NYPD was obligated to produce only existing records and not records that don't exist. So to whatever extent Ms. O'Neill is alleging that the police did not properly investigate something and therefore there aren't records, that's not the basis for a FOIL claim. FOIL claim is about records that do exist. So 62 records were found to be responsive to her 2019 request, which is the one at issue today. Only 8 of those records were withheld, and they were withheld because the request for them was time barred. She had made a 2018 FOIL request, which was denied, and she never challenged that judicially. Then in her 2019 request, she as part of that request, that the 2018 documents requested were repeated, and that was for everything related to her CCRB complaint. So she cannot revive that request by simply making it again. It was denied. She didn't challenge it judicially, and therefore her time to do so had expired, 4 months to bring an Article 78 proceeding, and therefore those 8 records were properly withheld. As to the records that were produced, there were 54 records produced, and I will just note for a second that there were 62 records that were uncovered. Ms. O'Neill did point out in her reply brief, rightly so, that there was basically a mistake in our brief. We had said 65 at one point, but it was 62, which is reflected in the record and by the math. So the 54 that were produced did have redactions. They fell into 3 categories, only one of which Ms. O'Neill is now challenging, and that is the one 87-2E4 of the Public Officers Law, which she mentioned, which is information prepared or created for law enforcement purposes that reveal non-routine investigative techniques and procedures. Where the parties differ here is that she seems to be saying that there were many, many redactions of things specific to her cases, but the NYPD has certified that the only redaction that it is made under that exemption was a general list of investigative techniques that is automatically generated with electronic cases, not specific to her case. And in fact, she was given a list of steps that were taken in her case. So to the extent that she's claiming that there were other things that were redacted under the public officers law section that I just mentioned, it's just not true. So I can't respond to that in any other way because these redactions that she's talking about weren't made. To the extent that she thinks there should have been things, again, in the documents that don't exist, they weren't redacted because they don't exist, and FOIL is not the proper means of trying to pursue documents that don't exist.
Thank you.
Do I have any time?
You're out of time, but I'll give you an extra 30 seconds to wrap it up.
Okay, thank you. I'll just say that on the sanctions motions, the court properly exercised its discretion in denying those motions because most of the things that, well, some of the things that Ms. O'Neill complains about were mere advocacy. They had nothing to do with material misrepresentations. There was no evidence of malicious intent or anything like that. And the other things that she complains of, such as the attorneys calling her a liar and being crazy and having drug addiction and mental issues, they're nowhere in the record. I can't respond to those because they're just not there. There's no evidence that these things happened. They're not in the record, and therefore I can't address them. Certainly, if you look at the documents that were submitted below by the two attorneys that she has accused in her sanctions motions, none of those things are in there. So for that reason, we'll ask you to affirm. Thank you very much.
Thank you. Ms. O'Neill, you have time on rebuttal.
Yeah, the arguments that Corporation Counsel just made don't even make any sense. So if there's nothing on record in the police report to show that I'm a liar, then how come the NYPD picked up the phone a couple weeks after I filed my petition and told my former employers that I was a liar? So where's that information coming from? They're just materially decided? I mean, where is it? So the arguments that she's saying just simply do not make sense. And in this particular case, the NYPD has a pattern of behavior going out of their way to do harm.
She may be saying, Ms. O'Neill, I think she may be saying that to the extent that you say that happened, right? There is no report by anyone from the police department that they made such a call and made such a statement. That is what she is arguing.
Right, and what
So
I'm telling
she
you
can't
is,
give you a document that doesn't exist. If a police officer indeed did that, and I have no way of knowing one way or the other, right? What she is arguing is that they certainly didn't make a report saying that, and so she cannot provide you what she does not have.
well, what I'm saying is that the reason I found this out is an attorney for one of my former employers told me that the NYPD called them and said this. So I mean, I didn't generate this story. I was told this by a partner.
I understand, but do you understand that even if that's true, right? I have no reason to not believe that an attorney told you that, right? But even if that's true, that does not negate what counsel has argued, that there is no document saying that, so she cannot give you a document about that because there's no document to give. You understand?
Okay. Right, no, I understand that, but in terms of the motions for sanctions, what the NYPD did was they told the court that they filed an adjournment request and that they needed to look for new documents, and that's what they told the court in writing that they were doing. In actuality, what I found out after the fact is they were picking up the phone to the lawyers from my former attorneys, calling me crazy and calling me a liar, and trying to dig up information so that they could make baseless ad hominem attacks in their papers. So if you actually read their papers and their cross motion to dismiss, they include tons of information that is slamming me, which is frankly false, claiming I spun a tale and making other ridiculous false statements with providing no factual support. So they say I spun a tale, but they don't explain what tale I spun. They call me a liar. They don't tell me what I lied about. They call me crazy. They don't tell me how I'm crazy. So that's the problem, is that they make these very vague, very general statements. They don't have factual support. And so what she's arguing is that the NYPD just throws out these statements about people. They just say that they spun a tale. They just call them liars, but we have no documentation. We have nothing on record to support the arguments we're making. That does not make sense. The argument that they are making, which is that, we just say this stuff about people. We throw out rape kits, which is destroying evidence, which is a crime. We tamper with and destroy evidence, but we have no documentation why we do this stuff. We refused. They violated federal law. They had DNA. They had male DNA and sperm on a rape kit. They had acetone, a component of chloroform on another, and they wouldn't send me the results of my own rape kits. They made me sue them. I had to file an Article 78 petition just to get the toxicology reports from the OCME. So the NYPD is saying, oh, this is no big deal. We always act this way. No biggie here. We have no records. Bullshit. No one believes that.
Thank you so much.
You don't.
Thank you so much, Ms. O'Neill. Ms. O'Neill?
Treat me with no factual support. They have no factual support in the records they send me to support their actions, and it is not believable.
Thank you, Ms. O'Neill, and I assure you that this court will again review the entire record as we already have, but we will do it again, okay? Thank you so much. We're out of time. Next case, Galino versus Everest Scaffolding.
May it please the court, good afternoon, Your Honor.
Counsel,
Scott
hold
A.
on one
Brody.
second. Counsel, we have several attorneys on. Let's make
We have
sure
a lot
everybody's.
joining us.
I'm sorry?
We have a lot joining us.
Yes, I know. That's why I want you to give it a second.
No problem.
Okay, I think we've got everyone on board now. All right, so I will hear from Mr. Brody.
Thank you, Your Honor, and good afternoon, Your Honors. The fundamental purpose of the labor law is to make those persons in the best position to make the construction site safe, liable for injuries which occurred during the course of the work. Here, the underlying trial court, by rejecting contracts which every single one of the defendants submitted before the court and which SSG's own project supervisor identified as being true and accurate copies of the contracts entered into by the parties, has effectively denied the process that the labor law was designed to do by failing to allow the ownership entities to transfer liability to the entities that were on site performing the work. Two fundamental errors have occurred here. The first deals with the underlying facts. When the initial ownership entity was found to be liable and summary judgment was granted, the court found liability based upon the failure to provide a place where that employee, the underlying plaintiff, could tie in his harness. It's a simple fact. That fact was not followed in the second decision, and the court relied upon an expert who said OSHA did not require there to be a tie-in because there was 42-inch perimeter around the place where the gentleman was working. However, that position has two fundamental flaws, forgetting for the second the application of law of the case. If you apply law of the case, you can't change the facts. But if you don't apply law of the case, the expert opinion is flawed because A, he doesn't cite to a standard in OSHA that says that you don't have to provide a place to tie in if there's 42-inch perimeter protection. And second, OSHA is not the relevant standard here. The relevant standard here is was the protection provided sufficient to prevent the accident? OSHA is not a standard that applies to Labor Law 240. So from the underlying facts, the nature of the accident, we have a situation where my clients were found liable because there was no place for this gentleman to tie in. And then it's held that we're not entitled to indemnity because OSHA didn't require there a place for him to tie in. It can't be both ways. We can't both be liable and not entitled to indemnification because the reason we're liable no longer applies. With regards to the issues of the contractual indemnity claims, there are fundamentally 2 points which we believe are extremely important. First, everybody submitted the contracts and relied upon them. The only entity to raise an issue with respect to the contracts was the court, and the court simply overlooked the testimony cited in our brief and cited in the record of Mr. Ansera, who identified each and every contract as between my client, SSG, and SSG and Ramon. If you
Counsel,
apply,
I'm sorry, Counsel, this is Justice Weber. Just
Yes.
to interrupt for 1 second. Are you stating that the OSHA regulations did not require a tie-off?
Well,
is that what you're saying?
I am saying that while the expert says OSHA regulations didn't require a tie-in, he doesn't cite to an OSHA regulation that says that. He just says OSHA doesn't require a tie-in where there's 42-inch perimeter. Had he cited to a section of OSHA, we could confirm or deny that, but he doesn't.
Okay.
So he just says it. Yeah, OSHA doesn't require it. Well, last I checked, OSHA was a series of regulations that provide when something is required and when it's not, but he doesn't cite to a single section. Okay?
Thank you. I wanted to be clear.
No, I want you to be clear. So going to the contracts, there's 2 fundamental points here. The first is that the contracts provide for indemnity. It was clearly the intent of the parties to transfer the indemnity obligations from the ownership entities that weren't performing the construction to the entities that were, okay? Even theoretically, if the court simply overlooked the fact that SSG's own witness identified the contracts going in both directions, both up to the owner and down to the subcontractor, the court shouldn't have just totally ignored them and said, you know what, so there are no contracts, therefore there's no indemnity. Clearly, at worst, there was a question of fact as to whether or not the indemnity obligation existed in this particular case. The second issue,
you have
which
time on rebuttal.
Okay. Thank you, Your Honors.
Ms. Fuchs, you have 4 minutes.
Good afternoon. May it please the court. Cheryl Fuchs for appellant respondent Everest Scaffolding. The court erred in granting SSG and Ramon's summary judgment. Not to belabor Mr. Brody's points, but the point to address Judge Weber's question about OSHA, in New York labor law cases, there's lots of things that OSHA does require or doesn't require, but for New York labor law standards, there's a requirement for the general contractor to provide safety for their employees. And if the safety is not provided, then the statute's violated. For example, leading edge workers under OSHA do not need to be tied in, but if a leading edge worker is not tied in and falls down, then labor law 240 is violated. But besides for the fact that the court below relied on this expert who was first disclosed in motion practice and never inspected any of the equipment and has no basis for his opinion, besides for that and the prior decision of the court that said the reason this accident happened, at least in part, was because there was no tie-in, there's other avenues where SSG was negligent here and they should not have been dismissed. This bridge was installed 2 years prior to plaintiff's accident, and he was using it for 2 years without issue. Under Everest's contract with the owner, it was the owner, the customer's responsibility to inspect the bridge. They delegated that duty to SSG, who in turn delegated that duty to their subcontractor, Ramon. They did inspect that bridge every single day for 2 years, and they filled out logs, or the year that they were on the site, and they filled out logs. And if they had a defect, it was incumbent on them to find that defect. So whether they had actual notice of defect, they certainly had constructive notice if they're alleging that there's a defect. Now they claim that this is a latent defect. A month before this accident, SSG sent a letter to the Department of Building saying that this bridge was inspected and they certified it. So how can they certify a bridge if there is a defect that they're claiming? Now, just one other point I want to point out in terms of SSG is that just because an accident happened doesn't mean that the bridge as installed was defective. Plaintiff points out in his papers all the things that he extrapolates as to what was wrong with this bridge. As Renee Nunez, the supervisor for Everest, testified, a sidewalk bridge is meant for pedestrian protection. Now, if contractors use this bridge for their employees, that's their prerogative. If there was an area that was backfilled in, it was meant to cover so that debris, it protects the pedestrian and does not fall through. There was absolutely no requirement, contrary to what plaintiff says in his brief, that this bridge be attached to the building. In fact, it says it would not be attached to the building because it was a landmark building. So there has been no—
You're not suggesting that because it's a landmark building that it could be left in a condition where a worker could fall through, right?
Absolutely
It
not.
still has to be safe.
Absolutely not. But the point is that from Everest's perspective, they're putting up a bridge for pedestrian safety. It's the labor law puts the requirement on the GC to ensure that their equipment provides safety for their employees. So
Counsel, you have a cross motion and we're arguing everything together. Do you want to address that?
Well, since Mr. Brody did not address the section regarding Everest.
Counsel, don't worry about Mr. Brody. I've asked you a question. Would you like to address your cross motion? Or you can leave it for your 1 minute of rebuttal. It's up to you.
Sure. Just because an accident happened does not mean that the bridge was defectively installed. The expert has no personal knowledge and he never inspected the bridge. It was up for 2 years without any issue. And if there was a problem with it, it was up to SSG to identify and notify Everest of the problem. Thank you.
Thank you. All right. Next up is Mr. Celso for Galino. Mr. Celso? If you're talking, we don't hear you.
I'm sorry, Your Honor, I had you on mute. It's Mr. Norton. I filed my notice of appearance. Mr. Celso is no longer with our firm. I'll keep my remarks brief, just in response to the Everest claim that the decision failing to grant them summary judgment with respect to Labor Law 200 was an error. As this court rightly pointed out, regardless of Everest's own interpretation of their expectation, there's a responsibility that the sidewalk bridge has to protect the workers themselves. And there were gaps within the sidewalk bridge, and it's our contention that was not in it was not in coordination with the engineer's specifications, and it certainly wasn't in coordination with the New York City Building Code specifications, which violations were issued for these specific gaps within the scaffold that wound up playing a cause in the accident. I understand the argument that this is a unique building and there were stone outcroppings that required some sort of adjustments to be made to the sidewalk shed, but there's ample evidence within the motion practice here, within our papers and within throughout the depositions and other evidence that Everest failed to provide a adequate sidewalk shed to provide safety for workers. They provided these cantilever planks to cover up the exposed areas that were created by this unique nature of the sidewalk shed. So it was our contention that that was not in coordination with the engineer. This was Everest's decision to do so, and those planks fell through, causing injury to the plaintiff. So I think there's ample evidence here to suggest that Everest used defective planks, violated New York City Building Code and the engineer specifications, and that failure to provide a sufficient sidewalk shed, which we know that construction workers have to work on, regardless of whether or not its intention is to protect pedestrians below. It also has to protect workers. It didn't do so here. There's ample evidence of negligence. And
thank you.
I'll rest on my brief. Thank you.
Thank you so much. Ms. Wettinger, I hope I've pronounced it properly. You have 2 minutes.
Close enough. It's Wettinger. May it please the court, Laura Wettinger, on behalf of Ramon from Barry McTiernan. And I'm going to also be very short and to the point because our main issue really is the contractual indemnification portions of it. And I just have to point out that Everest has no contractual relationship with Ramon Construction whatsoever. And with regards to, I'm going to say Elk to make it easy. Elk has asserted it is the owner of the property, and it also is asserted, and it is the party found liable, statutory liable under the labor law, and it's also asserted that it does not want and is not seeking contractual indemnity from me. They are trying to seek contractual indemnity on behalf of a lessee, and that is not included in the contract language. And unless the court has questions, I will rest on my briefs.
Thank you so much. And last but not least, Mr. Cavini. I hope I pronounced yours right. If you're talking, we can't hear you. Have I so mangled your name you don't recognize it? Andrew Cavini, counsel for SSG Group. I see you in the in our, but we don't hear you yet, counsel.
Lips are moving, but we don't hear them.
Mr. Cavini, you may want to log out and try to log back in so that we can get your argument in. Okay, I think he's trying to do that. So let's give him a moment. The perils of virtual argument. Oh, good. He's trying to get in. There. Mr. Cavini, are you with us?
I am. Can you hear me?
Yes, wonderful.
Okay, I apologize. It was working for 2 hours and then it stopped.
Of course. We will hear you now, sir.
Okay, the issues regarding, just your introduction, my name is H. Keaveney. My firm represents SSG, or Schellenbacher Sending Group, which has been referred to SSG in papers. In terms of the law of the case argument that has been raised by both appellants, the initial decision by Justice Tapia analyzed Elk's liabilities under 240 and 241-6, and that's how it made that determination. When Justice Rosario looked at the issue, she was looking under a different standard. And SSG is the only party that submitted expert proof to demonstrate that it was not required for its workers to wear or to tie off while working on top of the sidewalk bridge. So the fact that there was no anchor points there, as Judge Tapia decided in the initial decision, is irrelevant to determine whether or not SSG was negligent at that time. And that plays also into the contractual indemnification arguments, because under those provisions, a party has to be found negligent or for the accident, as opposed to an arising out of obligation, which is not present in these contracts. Regarding whether or not we sustained our burden in eliminating all trialable issues of fact, our expert again said that the bridge itself did not require its workers to be tied off because of the perimeter edging around it. And plus, there was no labor law claims asserted by plaintiff against SSG. In fact, SSG was never a direct defendant, although plaintiff certainly had the opportunity to bring in SSG as a direct defendant. The issue here is simply that plaintiffs, that 20 West contracted with Everest to build a sidewalk bridge that collapsed under plaintiff's own weight. That is the problem. Plaintiff did not fall off the side of the bridge. He fell through the bridge, which is definitely significant in determining whether or not a tie-off would be required in this situation. And our expert, the only expert, said that it was not necessary. And with that, I'll rest on my papers.
Thank you so much. Okay, going back now to Mr. Brody, you have 2 minutes.
I'm going to raise 3 points as quickly as I can. First, with regards to Ramon's argument that the two entities that initially brought the contractual indemnification argument and Elk are entitled to indemnity from Ramon. Ramon ignores the fact that its contract with SSG, SSG's contract was with 20 West, was the contracting party, ABS was its managing agent. The indemnity agreement specifically provides for Ramon that it has to indemnify the owner, their agents, and their agents' employees. Our clients were found liable under Labor Law 240 because it applies to the owners and their agents. So if my clients are liable under the labor law, in order to be found so, they have to be found to be agents of the owner. If they are agents of the owner for purposes of the statute, contractual language that says it will indemnify the owner and its agents must apply to the agents found liable. So Ramon's argument there fails. As to Mr. Keaveney's argument with regards to SSG, even if OSHA did not require this gentleman to be tied off, Labor Law 240 requires him to be protected from an elevation-related risk. He was provided with a harness from which he tied off at every other location but this location. If they weren't going to provide him a tie-off, they had an obligation to do something else to do one thing, prevent him from falling. They didn't prevent him from falling, and the judge found the reason they didn't prevent him from falling is because he had a harness with no place to tie in. SSG was negligent for failing to prevent the employee from falling. They are liable. With regards to Everest,
you have 30 seconds.
I know, I'm going. CPLR 4518 is adequately addressed in our brief. We believe that the CIR is applicable in this case, which gave Everest a contractual duty to indemnify our clients. You have heard the arguments about the negligence with regards to the planks. If in fact there was a negligent installation, since they are not the employer, they have no workers' compensation bar, and common law indemnity applies. Both of those issues are going to be left for trial. We understand that. However, we believe the contractual indemnity language is clearly applicable here, and a conditional order as to Everest should have been granted. I thank you, Your Honors, for your attention.
Thank you. And last but not least, Ms. Fuchs, you have 1 minute. You have to unmute so we can hear you.
Sorry. Just very briefly, in terms of the contract, the affidavit that they tried to use to authenticate the contract says absolutely nothing. It doesn't say that he signed the contract, that he saw Everest sign the contract. Nobody from Everest authenticated the contract. The only contract that was authenticated was the 3-page document that didn't require Everest to indemnify anyone. So that decision should stand with respect to the contract. And just to briefly address the other arguments, I'll say Mr. Keaveney's argument and plaintiff's argument. He provided an expert. His expert has zero foundational basis and should have completely been rejected by the court. And that expert inspected nothing, so he can't say what the condition as installed, whether it was deficient, whether it violated anything or not. And with that, I'll rest on my brief.
Thank you so much. And last but not least, People versus Kevin Townsend. Mr. Weiner, you are up and you have 5 minutes.
Thank you, Your Honor. Good afternoon. I'm Benjamin Weiner from the Center for Appellate.
Sorry.
Sorry?
Sorry for the mispronunciation. Go ahead.
Oh, that's totally fine. It happens all the time. Please don't worry about it. At any rate, I represent Mr. Townsend. There was no reason to doubt the police officer's testimony at the hearing that when Mr. Townsend was surrounded by 5 other police officers, transported 20 feet away from the complainant and detained while the complainant was questioned, that Mr. Townsend was not free to leave. Any reasonable person subject to that conduct by the police would have understood reasonably that he could not simply terminate the encounter and walk away from the police. And that is the hallmark of a level 3 seizure. Respondent has never explained why it was reasonable for Officer McCoy to perceive that Mr. Townsend was not free to leave, but it would have somehow been unreasonable for Mr. Townsend to hold that view. Along similar lines, there was also no reason to doubt the officer's testimony that the reason he asked Mr. Townsend whether he had a knife was to investigate a crime and not to clarify an ongoing situation or for the officer's safety. That too was borne out by the facts here. The dispute, the argument between Mr. Townsend and the complainant had clearly ended at that point. As I said, Mr. Townsend had been removed from the complainant. He was surrounded.
Well, counsel, this is Justice Weber. Just a couple of questions. So the testimony was that the officers actually observed the altercation, the verbal altercation between the defendant and a male as well as a female. It's a female and a male stepped in. Is that correct?
Yes, Your Honor.
And then at some point in time, and that was because someone had alerted the officer to this altercation. Is that correct?
That's right, too, Your Honor. Yes.
And then once the officers spoke to the female, she stated that the defendant had threatened her with a knife. Is that correct?
That's also correct, Your Honor.
So why would it be improper for the officers to inquire of the defendant as to whether he did or did not have a knife?
Well, Your Honor, because Mr. Townsend was in custody at that point. And so
why would you say that? I'm sorry, but why would you say that he was in custody? He was escorted a short distance away from that altercation, and he was being spoken to. There was a conversation between he and the officers. So why would this constitute? Because your whole argument is that there should have been a Miranda warnings, right? So why would this constitute custodial interrogation?
Well, for those reasons I pointed out, Your Honor, I think it would have absolutely been unreasonable for Mr. Townsend to think that he could have just walked away from the police officers at that point. And that is the definition of custody. If you're not free to leave, if your liberty is being restrained, you have been subject to a level 3 seizure and you are in custody. And so we're not saying that the officer couldn't have asked this question. He just had to provide Miranda warnings first if it was going to be introduced in the people's case in chief at trial. That's what we're saying. And again, those objective circumstances establish a seizure here and are confirmed by the officer's testimony that Mr. Townsend was not free to leave. I do briefly want to address the right to counsel point as well, because I think the facts are somewhat extraordinary here.
Counsel, I just want to warn you, you have about a minute left. Go ahead.
Thank you so much, Your Honor. I appreciate that. Within hours of being appointed to represent Mr. Townsend, counsel realized that he wasn't actually qualified to continue representing him because he wasn't on the felony panel. And rather than informing Mr. Townsend of this or talking to him at all about the decision whether to testify in the grand jury, which was clearly tremendously important to Mr. Townsend, he had no discussion with him at all, showed up the next day in court outside of Mr. Townsend's presence, waived Mr. Townsend's right to testify in the grand jury, and in essentially the same breath asked to be relieved, which request was granted.
So Mr. Townsend previously had an attorney who had made the same determination, right? That he would not testify before the grand jury?
Well, no, that's right. And that was the source of dispute with Mr. Townsend so significant that it led to a complete breakdown in their relationship. And that's why new counsel was appointed to represent Mr. Townsend.
So, counsel, my understanding, and I know you're running out of time, so my understanding of the law is that an attorney has the right to waive the defendant's ability to testify before the grand jury, and that because it's strategy, it may in fact be strategy. But even if the attorney does so, the defendant must show prejudice. So, is there any showing of prejudice here?
There's not, Your Honor, but this really is, I think, quite different from Hogan in the ordinary run-of-the-mill case where counsel, in the long course of representing his client, maybe deficiently ends up forfeiting his right to counsel or to testify in the grand jury. That's Hogan. But this is, again, it's a shorter than 24-hour representation where counsel does nothing other than realize it's not going to be qualified. I'm sorry.
Go ahead.
Does nothing other than realize he's not going to be qualified to continue to represent Mr. Townsend and waive his right to testify. That's it. That is just does not meet the baseline.
But why is it simply not a reaffirmation of what the first attorney stated?
Well, it really would have been unreasonable for counsel to rely on the first attorney's assessment, because the whole reason he had been appointed was to make this decision because prior counsel had a conflict with Mr. Townsend over this very issue. There would have been no point in appointing new counsel if all counsel needed to do was just rely on the determination that the previous conflicted lawyer had made.
Okay,
Sir, I'm sorry if I missed.
You'll have time. Go ahead. I don't want to stop one of my judges from asking a question. Go ahead.
Sorry. Sir, did I understand you correctly that you don't, you're not arguing that there was any prejudice stemming from the decision not to permit defendant to testify before the grand jury?
That's right, Your Honor. We're arguing this was tantamount to a complete deprivation of the right to counsel for which prejudice need not be shown, and also was not meaningful representation under the state constitution, again, where you don't need to show prejudice.
Thank you. All right, Ms. Stackhouse, we'll hear from you. You have
Good
4
afternoon,
minutes.
Your Honors. I just want to correct what counsel stated about the standard for a seizure. The standard is actually whether a reasonable person, not that they would have felt that they were free to leave, but whether the officer's conduct was a significant limitation on his or her freedom. And there was no significant limitation on defendant's freedom in this case. He wasn't taken to a police station. He was walked 10 feet down a hall. He was separated from a woman who he had just been arguing with. This is a function of the officer's peacekeeping duties. I wasn't forcible. Nobody touched him. Nobody yelled at him. And the timing is very important. This wasn't a prolonged detention. It was very brief. It was a minute at most is what the officer testified to. And at that point, the woman said, "This man threatened me with a knife." And even under a level 2, at this point, I would argue that it's risen to a level 3. They have reasonable suspicion that, if not probable cause, that the defendant has a knife. But even under a level 2 stop, this court has said that the officers are permitted to ask, pointed investigatory questions, including whether a person has a weapon. In terms of, counsel admitted that there was no prejudice in this case in terms of the counsel claim, and I would just argue that he wasn't constructively denied counsel. He had an attorney. The attorney made it very clear he was representing him. The attorney had been present for the prior court appearance for defendant. I think we had a bit of a scene with the judge and with his former attorney, and he had all of the information that he needed to make the decision that he did not want the defendant to testify in the grand jury.
But we don't really know that much about that decision because we don't have a 440, right?
Exactly, Your Honor. That's the other point. The court shouldn't entertain this claim unless the attorney is given the opportunity through a 440 hearing to explain why he didn't want the defendant to testify in the grand jury.
Okay, thank you.
Thank you.
Mr. Weiner, you have 1 minute.
Thank you, Your Honor. In terms of the standard for seizure, I want to just refer Your Honors to page 13 of our brief, 2 of this court's cases, In re Brandon D. and People versus Major, which make clear that that restraint of liberty standard that that counsel cited is the same as saying not free to leave. Those are the same standard. So that is the question at level 3 is, was the person free to leave? And Mr. Townsend absolutely was not here. I also want to just go to counsel's point about the fact that at level 2, they could have asked him whether he had a knife. I think that is a significant point in our favor. The police didn't need to seize Mr. Townsend in order to assess the situation here.
I'm sorry, I didn't hear what you said. The police did not.
They didn't need to seize Mr. Townsend in order to effect a level 3 stop in order to ask him whether he had a knife. But they did effect a level 3 stop, and that was completely unnecessary under the circumstances, given the law that respondent cited.
How would that have been a level 2 or level 3 stop? I'm not understanding. Why would it you said it constitute a level 2 stop? Why would it constitute a level 2 stop?
Sorry if I wasn't clear, Your Honor. Our position is that this was a level 3 stop. respondent made the argument that if it were a level 2, they could have asked even at level 2 whether Mr. Townsend had a knife. And my point is merely that that goes to show that they didn't need to seize Mr. Townsend here, but they did seize him. They surrounded him, they moved him, they detained him, and under those circumstances, that was a significant constraint on Mr. Townsend's liberty that was unnecessary and that counted as a level 3. And I would also point out, respondent just now said they had reasonable suspicion. I don't think that that was in their papers. If I missed it, forgive me, but I don't think it was in their papers. I think they've always said all along that this, there was no reason. They've never argued that point as far as I can tell.
Thank you so much. We are out of time. We have your briefs and the record.
Thank you.
This concludes the session of the Appellate Division First Department's oral argument for today's date. Have a good night and be well.